Good evening, everybody. I'm Bruce Tammi. This is my third and final series on decision making. And this series is sort of what you might be more used to as far as getting a lecture from lawyers or something on estate planning. It's sort of like estate planning 101, but I'd like to think of it more along these lines of passing on property efficiently when you pass away. So the question becomes, what happens when you die? Where does your property go? Who receives your property when you die? In Wisconsin and in most other states, and probably even most other countries and things, it varies. It varies by how you own your property. How is it titled? Is it just in your name? Is it in your name and your spouse's, or your name and one or more other individuals? So that makes a difference. And it does make a difference, at least in Wisconsin, if you are married. And that can be, it can be between the traditional type of marriage or a domestic partner, too, if you're in that sort of circumstance. And I'll talk a little bit about that. Why does it matter? In Wisconsin is, if you're married or you have a domestic partner, there's something called the marital property law. And some other states have it, but many states don't have it. Marital property law gives a spouse a right to property typically acquired during the marriage, that is, after they're married. So it can exclude property, for example, brought into marriage or inherited, or somehow that doesn't have to do with either of the couple's endeavors in working or investing. But it can be a complex sort of situation, and it can be varied too for between couples. They're called marital property agreements. It can be a prenuptial type agreement that varies these laws too. But in general, under the marital property law, your spouse has a 1/2 interest in property. Each spouse has a 1/2 interest in property that you've acquired while you were married. And that's even if it's titled only in one of the spouse's names. So, for example, my wife and I own property, and even if it was just titled in my name or her name, if it was acquired typically during your marriage, even though it's not titled in your name, as a spouse, you have a typical 1/2 interest in the property. But it can be complex, so that makes a difference. Other things that make a difference is how you own the property, whether or not you own it as, we talked a little bit about solely as an individual, or jointly with someone else, with your spouse or someone else. And also whether or not your property, you've named beneficiaries on property. And I'll get to that in a bit. I bet a lot of you have done that. Life insurance is a typical thing. On a life insurance policy, you name beneficiaries of it, one or more beneficiaries. But you can't do that on a lot of other property, and I'll get to that in a little bit. Now I'm going to get to some sort of typical situations. I'll start with husbands and wives, or spouses. And say that you get the question, my spouse and I own all our property together, basically the real estate, our bank accounts, we're both listed on it. Financial accounts, we've named each other as beneficiaries on our retirement accounts and on our life insurance. Is that typically good enough in Wisconsin? Answer is, yeah, to transfer between spouses, because basically if you own everything in Wisconsin as spouses, together, unless you've designated it some other way, but if it's in both of your names, it's considered marital, survivorship, marital property, sort of like joint tenancy. What that means is you both own it together, you both can access it, and upon your death, the survivor gets sole ownership of it. And this is regardless of what it says in a will or trust or anything else. So that's sort of an automatic thing. So as a couple, if you've got everything set up that way, typically it's going to take care of things if one of you passes away. But then if it's the next step, well, what if one of us dies and then the surviving spouse gets everything? Then what happens? Well, that's a totally different circumstance. So, another question becomes, as a spouse, I was talking a little bit about marital property and things like that. So, but what if I have an account just in my name, or accounts just in my name? What happens to that? And I'll go first into the situation if it's spouses. Okay, if you own property, say one spouse, and I've had this happen numerous times in my career. A lot of times it's second marriages and things like that where accounts are kept separate. But not always. Sometimes spouses, for whatever reason, want to have their own account, their own bank account here, and the other has a bank account. You might have accounts together and things like that. But what happens in that sort of situation if you've got property that's separate, maybe some stuff together, some separate? Well, in Wisconsin, even though let's assume first that you have a will and stuff that it would pass on regardless. And that will typically do it. A will typically passes your solely owned property on to who the will designates. And like I talked about a little bit, as a spouse, you have these marital property rights and things too. But if you, for example, are a couple and you have one of the spouses dies and has property over $50,000, that's and I'll get a little bit back to that. But if you have, for example, bank accounts, real estate, or what have you, that doesn't have a designation of a beneficiary on, isn't co-owned, jointly owned, where it automatically would go. In Wisconsin, if it's over $50,000, even if you have a will, there's probably going to be a probate procedure needed to transfer this property over to your spouse, okay? The reason is, what's the $50,000? Well, Wisconsin has a law that allows you, if your total property is, you pass away, and this is single or married, if you have property and it's less than $50,000 that has to be transferred to someone else, you can do it without a probate procedure. There's an affidavit of transfer and things like that. It's a simplified procedure. So that can be used in certain circumstances. Now I'm going to go to a little bit of a different circumstance too. What happens if you have no will and you have everything, or you have property just titled in your name, solely owned, you have no will, and you have no, what happens to property in Wisconsin? And this varies a little state to state, but in Wisconsin, typically, if you're unmarried at the time of your death and you have no will and you haven't done beneficiary designations and it's not jointly owned, where does the property go? Well, again, if you have a spouse, it goes to your surviving spouse, except that in Wisconsin, if it's a second marriage or a third marriage or whatever, and you had children from a prior marriage, when you passed away, leaving your spouse, in Wisconsin, your spouse gets 1/2, and your children from prior marriages or prior marriage get the other half of the property. And that in Wisconsin, so for example, if I died and I'm married and I have no will and I have children from another marriage, it would be divided, my estate, anything in my sole name. And again, we're putting aside this marital property thing too, because that can get into it too. But let's just put that aside. Typically, 1/2 would go to my spouse, 1/2 to my children from the prior marriage. And if one of those children, and this happens, passes away, if they had children, their share goes to their children. It basically goes by blood in Wisconsin. So first off, it goes to your spouse. If you have no spouse, if you look at number 5, where does your property go? Well, you have no children, you have no spouse. In Wisconsin, the first place your property would go to your parents if they're alive, or one or both of your parents. And that's usually not the case. Usually, in most instances, your parents are going to predecease you. And if they're not around, then the next in line, again, it goes by blood, are your siblings, okay? And so it would be equally divided between your siblings if you had no will. And if one of your siblings died, their share goes to their children if they have any. If they don't, then it just goes to your surviving siblings. If you have no surviving siblings or children, their children or anybody else, so you have no spouse, you have no parents, you have no children or any descendants of them, then it actually goes back up and it would go to your grandparents. Of course, they're probably not alive, right? But if they were, it would go to the survivor of one of them. Typically, I don't think I've ever had that happen, but it goes up further by blood, and it would go to your grandparents' heirs, which would be your uncles and aunts. And if if any of them died, then it goes to their children, your cousins. So that's basically the way it goes. If you have no will and you have property solely in your name, and you have no surviving spouse or children. But let's get back to a more common situation. What if you do have a will and you have things, and this happens many times, you have property just in your name that's going to be passed by the will. Again, we're excluding from what the will is going to do anything that passes by beneficiary designation or that you co-own with somebody jointly. Because in Wisconsin, if you have named a beneficiary on an account or you set up a joint account, even if your will says something different, it goes to the joint account holder that survives you or the beneficiary. That's just the way it goes. What are some ways to and another thing, getting back to last wills and testaments, if you're passing on property through a will, solely owned property, under any of those circumstances, again, if it's over $50,000 in value, total property that has to be distributed in accordance with your will, if it's over $50,000, you're going to need a probate proceeding in Wisconsin. Now, probate proceedings aren't horrible, but a lot of people try to avoid them. I've done many in my career, and there can actually be some advantages to probate proceedings in wills as opposed to beneficiary designation. In some instances, families don't get along, or there may be complex situations too, where just naming beneficiaries is not going to carry out what you want. For example, if you want things to go to minors, minor children, things like that. There can be other instances too where you want the sort of security of this probate procedure because it's court run, to make sure things get distributed equally too. One thing keep in mind too, if you set up everything through beneficiary designation or joint ownership, that automatically goes under Wisconsin law to the joint tenant, surviving joint tenant or tenants, or the beneficiary. But for example, if there are outstanding expenses, even funeral expenses and things like that, then the question becomes, if you put these beneficiary designations on accounts of different people, who's going to pay them? Who's going to pay your funeral expense? Things like that. So you got to consider that too. I mean, there are ways around that. You can prepay funeral expenses and do things like that. In a lot of instances, families get along and they'll come together as far as getting that done. Now, how do you, easy ways to bypass probate and, actually bypass the need of a will and things and get your property to someone else, again, are through beneficiary designations. That varies from having things co-owned, putting somebody jointly on an account. If you add someone jointly to your account, in Wisconsin, typically they have as much ownership interest in it as you have. So you might trust them and things like that, but there are a lot of things that can happen. If you've designated somebody as a joint tenant and they have financial difficulties, and have creditors going against them, they can go against your accounts to this jointly owned account. Or your joint tenant can pull out all of the money or do basically anything you could do with it. Beneficiary designations are different because when you designate a beneficiary on property, and that can be a bank account, it can be, of course, a retirement account, it can be on any basically financial services account, investment account. It can even be on real estate if you want to name beneficiaries, okay? And for most financial accounts and life insurance and things like that, it's fairly easy to do this, and you really don't need a lawyer to do it either. Basically, for financial accounts, bank accounts, financial accounts, you basically go to your bank, or if you have somebody who's assigned to you, like an account manager or something like that, talk to them, how do I add beneficiaries onto my account? And they can tell you. Typically, they have their own forms, and you set it up right directly through the bank financial services company. Same with life insurance and retirement accounts and things like that. Talk to whoever's, if you have an advisor or you have somebody assigned to you, you talk to them, or just in general to the company, and they'll tell you what has to be done and how you set these things up. You can actually name beneficiaries on real estate. That is a condo, a home, a vacation home, what have you. And I'm talking about in Wisconsin, laws vary state to state. So some states you can't do this. But in Wisconsin, you could add beneficiaries to any of your real estate. And what that does is, no matter actually what you say in your will or anything else, if you name beneficiaries on the property and you still own the property at the time you pass away, it goes to your named beneficiaries. It's fairly easy. You've got for the beneficiaries, upon your death, there's a form that's filed with the Register of Deeds, and there's also an online form that's filed with the Wisconsin Department of Revenue. But it's all fairly easy and can be done. You might want to get a lawyer to help you out if it is set up to get the property transferred, because it goes through the Register of Deeds. And setting up a transfer on death, that's what it is. Typically, on bank accounts, financial accounts, you've probably heard of it, POD accounts, payable on death accounts. For real estate, it's transfer on death. And to do that, though, you probably should get a lawyer, because you need a lawyer that's experienced in real estate or estate planning to add beneficiaries to real estate. Because you've got to fill out a form, it's got to be done correctly, it's got to be recorded with the Register of Deeds. It's not something that, you know, the ordinary individual, even somebody who has a little experience in real estate, can really take care of. So you're going to have to find an attorney that does that sort of thing. Okay, I talked a little bit about beneficiaries, wills, and naming beneficiaries on property, or having co-owned accounts and things like that. What are other ways that you can bypass probate and might actually be a good way of you transferring properties? One way is through trusts. You've probably heard of that. Some of you may have trusts yourself already or have considered it. There are all sorts of different trusts in Wisconsin and throughout the country. They're used for many different things. The type I'm going to be talking about now, and the typical type you'd be interested in for most people, as far as, you know, as an alternative to a will or other things, would be a revocable living trust. Living means it's something you creating while you're alive. It doesn't come up after you die. It's created while you're alive and actually funded while you're alive. You transfer, basically, it's done by a trust agreement that you forms the trust. It's not identical, but it's a separate entity. It's not like a corporation or an LLC or something like that, but it has sort of the same characteristics in that it continues, typically continues after you pass away. It's good now, it's good after you die. So it's something that doesn't, as you pass away, and you don't have the ability then to transfer property because you've passed away, but the trust has a trustee. And typically in the sort of living revocable trust that you set up, you're the initial trustee, you and your spouse. It can vary. But typically, in most instances, you'd create a trust where you're the initial trustees, and basically you can add property to your trust, you can take property out, basically do whatever you want with your property while you're alive. And then you also set it up so that there are successor trustees to you or you and your spouse if you have a trust. And the successor trustee would take over from you as trustee, managing the property and carrying out what the trust says. Typically after you've passed away, but it can also be if you become incapacitated, either temporarily or permanently, lose your ability to make decisions. And I've had numerous clients that have had trusts decide at some point in time, I don't want to be trustee anymore. You know, I'd rather have my successor trustees take over, and you can do that also through the trust. So the one thing about a trust is that it, again, I said it continues after you pass away. So unlike a will, which has no effect until you die, and then that is triggered to take care of your property, and typically requires a probate procedure. Your trust has been created, a separate entity with a successor trustee who's in charge, continues on. And basically, then the trust itself would have sort of the same provisions you'd have in your will, who you want to get your property upon death, or at other points. Sometimes trusts, you have situations where you have beneficiaries you don't think can handle the property, or might be mentally disabled. There can be all sorts of circumstances where you actually want the trustee to continue to hold property and use it for the benefit of a beneficiary. That can be done too. Typical case is a minor, of course. They can't manage their money themselves until they're adults. So, for example, if you have a trust and you want part of your property to go to grandchildren, some of the grandchildren are minors or others, trust is good because the trustee can still hold this, and then when they reach and use it for their benefit while they're still minors, and upon typically a certain age, then the trustee turns it all over to beneficiaries. So it can be very efficient and very flexible. And also it's good too because it gives a certain amount of protection, more protection than, for example, powers of attorney and things, as I said in my previous presentations, are really important in things. But a trust has the benefit that you've put all of your property or most of it in the trust. You're appointing a trustee. Now, a trustee can be an individual, it can be a bank, there are all sorts of trustees that there can be. You can have co-trustees. But it's sort of a more protected situation because you have everything consolidated and you've already appointed somebody that you trust that's going to take over and make sure it's managed properly if you can or you pass away. So it's good from that standpoint as opposed to just appointing a POA, power of attorney, in charge of your assets, because then basically there's no guidance there. There's no trust saying you do this or that with the things. So it is a little more secure that way. From my standpoint, it's good in instances if you have a bunch of property. The more you have, the more worthwhile it is. If basically you have limited amounts of property, and you don't have a complex situation as far as distributing assets upon death, you know who you want to get it, but it's not complex and no minors involved and things like that. Typically, you can just get away with something much simpler than a trust, beneficiary designation. You can't have joint or co-ownership too. So this all gets weighed in doing things. So again, my best advice, I'm just trying to give you some of the options out there for managing property and managing how it's distributed or after your death. Best advice, if you're considering trusts or things like that, trust is not something that you can do yourself. You can go online and you can get a trust, or I think there are even online trust makers where you can sign up and get a trust made. But I wouldn't advise that at all. It's too important to document, and if you make mistakes in doing it, it'll actually cost you, not necessarily you'll be gone, but your beneficiary is a lot more in the long run. So it's better to get it set up right in the first place. So I definitely advise anybody considering a trust to have a lawyer help them out with that. What else should you do? Say you've made your decision how you're going to set up transferring property upon death. Say you've gone through the process of setting up a trust or a trust and a will or anything else. You've got everything pretty much in place. Should you just leave it there and forget about it? Answer is no. The first thing you do when you put together estate plans is to make sure that the people you've put in charge, whether it's a nominated personal representative or executor in a will, whether or not it's somebody you've designated as your trustee in your trust, you make sure you want to talk with them and make sure they know what you want done. The trust will, and these things will say, the basics of where things are going, but you want to talk to them and make sure they're online and in agreement with what you're doing, because you don't want anybody that disagrees with you later in any of those roles. You also want to talk it over with family, especially if you have a fairly complex situation, or you have a division that isn't going equally between family members, or might be going this way and that way and other ways, and that's perfectly fine. But make sure your family understands this too, especially parents, children, things like that. Sometimes I've had numerous circumstances where, for any number of reasons, parents or whatever don't want to divide it equally between children. Maybe because one child has been tremendously successful and doesn't need it. Other instances, they've grown apart, unfortunately. That happens in families too. But the thing is, I've found to sort of tone things down when you pass away, make sure everybody knows what what you've decided during your life, how I want things distributed. So it can be really difficult in talking to family members if you're sort of cutting them out, or things you have somebody else in. It can even be who you're putting in charge as a personal representative or trustee. You just say, this is my decision. Because I've come across circumstances while I was practicing law that, it's distrustful. If the parents or the person has been silent their whole life of what's going to happen when they die, and then all of a sudden it goes this way, and it's not the typical way, or not equally distributed, then there's a lot of distrust. So it's good to let again, it can be very sort of a difficult conversation, but to let your family know what you've decided. And finally, just don't let your plans sit there for years. Periodically review them, whether it's designations of beneficiaries on accounts, jointly owned accounts, having a will, having a trust, who you have in charge as the trustee or your personal representative executor, or your named powers of attorney on accounts, or your POD or TOD beneficiaries, or your in general, how you've decided to distribute things according to your will or trust. All of these things can change over the years. Circumstances change. Not only it can be the property you own, it can be the circumstances with beneficiaries or the people you've designated as trustee or power of attorney or whatever. All these circumstances can change, and so it's a good idea to periodically look at these, not every day or every month, but every once in a while do that to make sure that they're all in line with what's needed at the time. In fact, interestingly enough, I got a phone call today from somebody who said, I see you're doing this series on decision-making, and this is true. I think you should tell everybody that they should periodically review the plans that they've made. Because I have personally experienced that I forgot to do that. And there was this change, and so I think it's important that you tell the people you're talking to about this. So, and this is absolutely true. So I appreciate that. So that's basically my presentation. If there are any questions?
Could you just briefly touch on second marriages and property that was already purchased prior to the marriage?
Okay. If it's a second marriage and both spouses or one or the other are bringing separate property in, again, this is where the marital property law comes in, because even though you bring in property, say you bring in investment accounts and bank accounts and maybe in real estate and things like that from a prior marriage, or maybe before you married, bring that in. Even though you've brought that in, now if it just sits there and doesn't increase in value, doesn't generate any income while you're married, doesn't go up in value, if it just sits there, typically, yeah, that's going to still be yours, and your current spouse or the spouse at the time it died isn't going to have any sort of say-so over that property. But, for example, if you have accounts and investment accounts that have dividends, interest, go up in value, that is all considered marital property. So even though you've brought it in, that's why I said it was sort of complex, even though you brought it in from a second marriage, it might end up your current spouse might have some sort of interest in it. Again, if that's a concern at all, typically it's a marital property agreement, that you would do to, and I've done numerous in my career, because ideally you do it before you get married. You decide we're going to keep this separate. And it might change over the years, because all you have to do is add your spouse to the count or whatever, and that changes everything, even if you have a marital property agreement. That's typically, again, so yeah, can get complicated.
Basically, it's controlled by the marital law, pretty much.
Excuse me?
It's controlled by the marital law, pretty much, because everything is going to increase in the home. You had a home for 20 years, or more, increasing value and all that. So, for all practical purposes, it's split.
Well, yeah, but the thing is, it's if you've got an understanding between each other, the spouses have an understanding, and for example, you have property that's gone up in value or whatever, and you have, say, for example, somebody else, not your current spouse, named as children from another marriage or whatever, and you have this understanding, well, then your spouse isn't going to do anything, and that things can just pass on by beneficiary designation or what have you. Because typically for a spouse to claim a marital property right in properties that the spouse doesn't have their name on, maybe brought in from a prior marriage or before they were married, you have to bring a probate procedure to have this determined. That's not cheap. So in a lot of instances, if there's an understanding, yeah, this stuff is going to my kids over there, your stuff is going over here. Typically that'll be good. If there's any question, again, having a marital property agreement sort of solves that issue.
You can set them up in a trust, right? You can
You can put things in a trust, but again, a marital property agreement is separate. Even though, for example, you could create a trust with property, say before you were married, you could even have a trust, bring it into your marriage with property into it. If it's a revocable trust, which typically almost all trusts are, revocable means you can cancel it, you can do basically anything you want with it. But in that instance, the property in the trust is considered your property as long as you're alive, okay, if it's a revocable trust. So even there, your spouse technically could still get a marital property interest in that property, so.
You have an agreement with the spouse, that can be documented?
Oh, yeah. Typically, that can all be, that's exactly right. That's exactly right. And again, it all depends on, if you're concerned about that, then yes, you want to make sure you get good legal advice, get the proper paperwork in place, so.
Bruce, everything you said is revolving around Wisconsin law. What year accept my will under these conditions? Then I move out of state to Minnesota.
That's a very good question. Property rights and wills and things do vary state to state. Typically, and that's one thing I should have mentioned with a trust. The good thing about most trusts is they're usually completely movable between states because remember you have this separate entity that's holding your property. And it works well for people who have property in different states. If you have a Florida place or a Colorado place or a California place and your other place or a Minnesota place. And you can put property you own in another state in your trust, and then you don't have to worry about these other state laws as far as probate laws and things like that. Typically, trusts are easily transferable. So if you, and I've had numerous friends of mine and stuff, especially when they were working, they were all over the place. East Coast, West Coast, because they moved with their companies or other companies and things like that. And trusts work really well in that sort of circumstance because typically you usually want to have it looked over, maybe if when you go to a new state, just to make sure there's no tweaks that have to be made to it. But
what would a typical cost be for a simple trust?
I can't comment on that. Again, you have to get that can vary greatly, okay? Because what does simple mean?
Single family.
I can't. Again, that's easy enough. You just again, you have to contact a lawyer, find out what their typical charge is for those circumstances. So, but no, quite frankly, if when clients would call me, if I knew who they were and I had done estate planning for them before, done a will, and I basically knew what their property was and I updated it, I could give them a range. But if it's somebody that's totally new, I know nothing about their background, I know nothing about, basically what they have or what they want to happen, and I don't have the things I need, I would refuse, just like I'm doing here, to give a quote. I'd say, I'll come in, and for me, I didn't charge for a consultation for something like that. But I'd wait to get all the information I need, and then I'd give a quote on it. So even if you were calling me in my office and asking that question, I wouldn't tell you. I wouldn't say what it's going to cost. Because I'd have to know. the gift taxes really are not an issue these days. Now, that might change in the future. Wisconsin has no gift or estate tax, so you don't worry about that in Wisconsin. Whether you gift, you're transferring something upon death or you're gifting it, Wisconsin doesn't tax that. They haven't for 20-some years. The U.S. does, but at very high levels. Currently, you're right, there's an annual, and I think it's something like $20,000 now. You can, there's 17.5 or something like that. You can give to any individual without reporting it. So you could give any number of individuals 17.5 without it having any tax consequence now or in the future. But on top of that, you've got an annual, not annual, a lifetime estate and its combination estate and gift tax exemption. Currently, for an individual, it's just under $13 million. So if you've got more than $13 million, you got to worry about it. And if you're a couple, that's doubled, because you, as a couple, you can have up to about 20, it's just a little under that, 26 million or so, and pass it without any sort of U.S. tax return. So for the vast majority of people, it's not an issue. You don't worry about gifting things, because tax-wise, unless they change things drastically. I do have to add, though, that in 2016, the federal tax, this exemption, is scheduled to drop back to $5 million a person. Now, it was sort of the way they enacted the law. I forgot what year it was. It kept building up and up and up, and then it came back down. That's just what the law says. My feeling is, with a lot of rich people in Congress and a lot of rich people, the big donors, that it's not going to go away. There'll probably be legislation putting it back up where it is now. But no, for a gift and estate tax. And it's only United States. Again, the gift and estate tax are one thing. They count. Again, that's a lifetime exemption, so this $13 million for an individual includes gifts over that annual 17.5. So for example, if you gave me $100,000, 82,500 would be go towards this lifetime exemption that you have. So it's a combination of that. In the scheme of things,
What is the tax if you give more than yearly allowance for gifts?
again, you have this lifetime exemption currently of $13 million. So,
We just talked about a limit of $35,000 or something, for a couple of people to give something.
no, there is there's no such limit.
We were just talking about
17.5.
That's the annual exemption. That's this is the amount they don't count at all. It doesn't go towards. They don't even. So if you give any individual less than 17.5 in a year, the government doesn't look at that.
In other words, you could give someone $500,000 and they wouldn't have to pay taxes on it?
Correct, unless you've given before that 12,500,000. Right, because you have this lifetime exemption. Okay, so the lifetime exemption currently is just under $13 million for a single individual. Double that for a married couple. So even if you give 500, you could give me $1 million. I'm not related to you. You could give me $1 million. I'm not paying taxes on it, and you're not if that's all you've given in your life. So feel free to. No, most. That's why I'm sort of.
No, I will tell you the reason I know that it's a little south of 18
But that has nothing to do with it. This is a gift. This is not upon death. So anyways, as a practical matter, unless you're a very, I guess these days, if you're wealthy, very wealthy, get some legal advice. Again, if you have more than $13 million, get some advice. Or if you have more than 5, you might even keep an eye on it, just so you don't. But I'm not worrying about it. So.
Can you
Yeah.
put your IRA in a trust?
No. Not while you're alive. That's, yeah, one thing almost most property, almost everything can be transferred to a trust. You've got to transfer money into a trust or property into a trust for the trust to actually be effective. You can't just set up a trust agreement and it not be funded. You have to put the property in for it to be controlled by the trust and directed by the trust. But a retirement account, you can't while you're alive. You can make the trust the beneficiary of it. So you can have a beneficiary on your retirement account of your trust, and then it would get paid to the trust. But that's very complex too, because unless the trust is worded correctly, all of that money coming into the trust could be taxed immediately. And trusts, if income is taxed to a trust, it's at a very high rate, higher than individuals. So you have to be very careful about that. But typically, if you have a retirement account now, you can't transfer that to the trust because that would be considered a transfer under law. Actually, you'd be taking the money out of the account, and it might still be in the same financial services company, but they'd put it in an account, but it'd be considered coming out of your retirement account, be taxed to you immediately. So, yeah, no, that's one thing that you can't do. Again, it can be transferred to a trust, and trust can actually be set up so that it isn't taxed immediately, but it's a really complex thing. So, yeah. Any other questions? Thank you.